Good morning to all. Today we are going to discuss one case law from the Companies Act, that is Section 59, which relating to rectification of members. We all know that Section 59 relating to rectification of members, if the name of the member is not entered or falsely, wrongly entered, they can apply for the rectification of the members under Section 59 of the Companies Act. And in case it is not rectified, they can approach the National Company Law Tribunal under Section 59 of the Companies Act. In this case, is relating to is Hyderabad High-Tech Textiles Park Members Welfare Society versus Hyderabad High-Tech Textile Park Private Limited and 7 others. The observation given by the National Company Law Tribunal Hyderabad bench is that under Section 59, registered society can't seek rectification of shares or register of members or company's members. What happened is, in this case, the company has allotted shares to some members, that is some persons up to 98 to 100 persons, and their shares issued, but certificates were not issued. What happened? They formed a society. They filed a case against the company for not allotting the shares. The respondent company has came and argued that their society is not recognized as a person under the Companies Act, and society is not a member, so they cannot file this case. And there is no privity of contract between the company and the society. After going to the definitions under Section 2, subsection 20 and Section 2, subsection 55 of the Companies Act, the court held that the society is not a person, so he cannot file the case against the company under Section 59 of the Companies Act, and the petition is not maintainable, and they have dismissed the petition under Section 59 of the Companies Act. This is the crux of this case. Let us see what the case is now in detail. On 2/9/2006, Entrepreneur Associates, Chinta Mohana Rao and 98 others, and Hyderabad High-Tech Textile Park Private Limited, the company respondent number 1 entered into a share subscription agreement SSA. Accordingly, the Entrepreneur Associates were allotted the shares. However, the share certificates were not delivered to them, nor their names have been entered in the register of members till date. All the investors who became members of the company by virtue of SSA formed a welfare society named Hyderabad High-Tech Textile Park Members Welfare Society. The society is registered under the Andhra Pradesh Societies Registration Act 2001. The society filed a company petition under Section 59 of the Companies Act before NCLT seeking direction to the registrar of companies to rectify the register of members by entering the names of the allottees as per SSA and detailed project report certified by the IL&FS, an audit firm. I think so. Just come down. The society contended that there have been intentional delay in delivering the share certificate to the members who were allotted shares through SSA. Yes. The society contended that there have been intentional delay in delivering the share certificates to the members who were allotted shares through SSA and whose names are mentioned in the detailed project report for the year 2006. The company opposed the petition and argued that there being no privity of contract between the society and the company, the society has no locus standi to file the petition. Further, a society registered under the Andhra Pradesh Societies Act cannot maintain a petition for rectification of share register of members of a company registered under the Companies Act. The issue is whether a society registered under the Andhra Pradesh Societies Act can maintain a petition for rectification of share register of members of a company. NCLT Hyderabad bench referred to Section 59 of the Companies Act. Section 59, rectification of register of members. If a name of a person is without sufficient cause entered in the register of members of a company, or after having entered in the register is without sufficient cause omitted therefrom, or if a default is made or unnecessary delay takes place in entering the register, the fact of any person having become or ceased to be a member, the person agreed or any member of the company or the company may in appeal such form as may be prescribed to the tribunal or to competent court outside India specified by the central government in notification in respect of foreign members or debenture holders residing outside India for rectification of the register. NCLT, after hearing both the parties and perusal of the documents, under Section 59 of the Companies Act, bench noted that if the name of any person is omitted from the register or unnecessary delay takes place in entering in the register, then the person aggrieved or any member of the company or the company may appeal to the NCLT for rectification of the register. It was observed that Section 2, subsection 20 and Section 2, subsection 55 of the Companies Act expressly exclude society from category of member and company for the purpose of Section 59 of the Companies Act. Further, a society registered under the Societies Registration Act is not a jurisdiction person by virtue of being a body corporate like a company registered under the Companies Act. On the issue of whether the society can be considered as the person agreed in view of Section 59 of the Act, the bench held that a person who is a stranger to the affairs of the company cannot fit in the place of any person or any other person. The bench held that society is not a person for the purpose of Section 59 of the Companies Act, since it has no nexus with the affairs of the company which allotted the shares. The phrase person for the purpose of Section 59 of the Companies Act is not defined in the Act. However, the phrases such as other person and any other person are referred to in the provisions of the Companies Act 2013, namely in Section 147, subsection 3 of the Companies Act, which deals with liability of the auditor for the contravening the provisions of the Act, and Section 213B, subclass 1 of the Companies Act, which provides for investigation into the affairs of the company. The phrase any other person used supra expressly denotes the nexus between the person referred in the above section with the affairs of the company. Therefore, it can be said that a person who is stranger to the affairs of the company cannot fit in the place any other person for the purpose of Section 59 of the Companies Act. This is so because of the Latin maxim justum generis is a rule normally followed to interpret where a law lists specific classes of persons or things and then refers to them in general. The general statements only apply to the same kind of persons or things specifically listed. While holding that no nexus between the affairs of the society and the company has been established through pleadings, it was held that the society cannot fall under the category of person for the purpose of Section 59 of the Companies Act, hence cannot be an aggrieved person. Moreover, even assuming that the petitioner society herein can be construed as a person agreed for the purpose of Section 59 of the Companies Act, yet in terms of Rule 19 of Andhra Pradesh Societies Act, any society registered under Andhra Pradesh Societies Act 2001 is entitled to initiate legal proceeding touching or concerning any property or any right or claim of the society and not beyond. So society is not signed any contract with the company. So it is not aggrieved by the act of the company. It cannot file a case. As per the Andhra Pradesh Societies Act, it can file the case only its rights is affected. Here, its rights are not at all affected. Only the individual members' rights are affected. The society cannot file the complaint under the Andhra Pradesh Societies Act. The bench held that the company's petition filed by the society for rectification of share register or members is not maintainable. So what we have to see is whether the society have the right under the Societies Registration Act, which is the principal act governing the societies. Number two, the Companies Act we have to see. After going through these provisions, the Honorable NCLT held that the society is not a juristic person. It cannot file a petition before the Companies Act because it is not an aggrieved person. So it is a stranger. There is no privity of contract between the company and the society. Hence, the case is dismissed. It is not maintainable. So, any doubt on this, you can ask me now.
No, sir.
Okay. Thank you.
Thank you, sir.
Thank you.